Hi, thank you. Welcome for joining us for this third in the 5-part series on unfair dismissal and statutory illegality. My name is Gary Smith. I'm one of the partners in the employment team here at Knockhold Solicitors. And today we're going to look at right to work and those employees who lose that right to work, because this has had really significant consequences to businesses, because under the Immigration, Asylum and Nationality Act 2006, for any employee you have working for you who does not have the right to work in the UK, you can face a £20,000 penalty, and that is per employee. But for those situations where you know that the individual is working illegally and turn a blind eye to it, the fines are unlimited, and business owners can face up to 2 years imprisonment. So not only could you have very significant financial penalties, but you could also look at going to prison simply for not getting this area of law right. So importantly, in this area is your right to work check, and it is positive for employers that via the Home Office you can undertake a right to work check, which you can do online, and as long as you fill in the form correctly and honestly and properly, if the check comes back and says you are okay to employ them, but it subsequently turns out that they didn't have the right to work here, you will have a defense to any potential penalties. So it is well worth undertaking these checks on everyone that joins you. When you become aware that an individual may be about to or has lost their right to work in the UK, it does remain incumbent on you to follow a fair procedure. So you would meet with the employee to consult with them, understand what the issue is. You may look to obtain some further evidence from them, but ultimately, if you can't be convinced of their right to work in the UK, you would have to look to dismiss to avoid those potentially draconian penalties. And you would grant the right of appeal. The employee's employment would still have ended by that stage, so that is fine. Obviously, if they can then prove that you were wrong and they do in fact have the right to work in the UK, then you could look to reinstate. Now, this is, as we say, a very tricky area of law and very expensive to get wrong. So some top tips on this is firstly to take a copy passport and or some other ID from all new employees, wherever they come from, so you can prove that you've undertaken some checks that they have the right to work. You should undertake the Home Office check for all non-UK nationals, and then diarise for 6 months prior to their right to work expiring, maybe their visa or their work permit expiring. You should do that in a centralized calendar. You don't want it just in your HR manager's calendar, because if the HR manager leaves, what happens to their calendar and their accounts? Do we look sufficiently far ahead to transpose that into the new HR manager? Much easier to have a centralized diary that a few people can access and keep an eye on, perhaps on a monthly basis. But when you identify someone whose right to work is about to expire, perhaps 6 months before, you would speak to them and make sure they're aware that their right to work is expiring, because often it happens that they're not. And then you can have a constant dialogue with them leading up to the expiry, or hopefully the renewal of their right to work. I hope that's been of some interest to you. Our next session on statutory illegality will be those who lose qualifications that are necessary for their role, and I hope that you'll be able to join us for that. Thank you.